Palm Beach Gardens office, we have Allison Hertz. And from our Tampa office, we have Shawn Brown, each of whom are board certified specialists in condominium and plan development law. There aren't many of those in the country, and we have two of them here today. So what I'd like to do right now is turn it over for us to get started over to Shawn Brown from Tampa. Take it away.
Thank you, Jeff. And, also to give a little bit of background, question pop up in the chat was who's responsible for legislation? Well, Allison and I guess, have the fortunate or misfortune, depending upon your point of view, of being involved with the Florida Bar and reviewing legislation. And we don't get to make major changes most of the time, but provide technical comments. So we've lived this not just in 2021, but in 2020. I looked at this morning actually for the outline I had to do for the bar last year on House Bill 623, which effectively was this year's legislation. And if you look at the items that were in it, we're all going to get on them. Term limits, transfer fees, conflict of interest, natural gas, arbitration, official records. So without further ado, we've got a lot of material to cover, so let's dive into it. Next slide. So since it's a preview, we're required to put up the disclaimer that this following preview is rated R. And the rated R simply means when you're dealing with legislation, half the time you just go, really? So that rated R is for really, because when we get into this, that's going to be a lot of your thoughts. And yes, this really all did pass the legislature, and most of it is pending signature by the governor, and we expect most of it to pass. We will note what has passed and what hasn't, though. So since we've got a long way to go and a short time to get there, I feel the need for speed because we're doing a summer blockbuster preview. So let's dive into this fun stuff. Legislation in Florida. We are our own unique world, different than any other place based on what I can tell. So we're going to tell you what happened during the legislative session because we know you want to know. The laws are generally designed to take effect July 1, and we're staring at that date about 6 weeks out. So here we are to tell you what happened. What passed? Well, that's a great question. What did we pass this last session? In short, everything. We're only highlighting the community association stuff. If you count the stuff that is generally real property related that we're not covering, such as growth management, remote notaries, public redaction, there's probably 12 to 15 pieces of legislation affecting real property out there. So despite it being a pandemic year, the legislature decided to pass everything. So let's dive in right off the bat. The COVID-19 immunity, Senate Bill 72, which is effectively the first law the governor signed, and it took effect in March of this year. And so what is in the COVID immunity bill? It's the one that we've all heard about. Lots of interesting things in the immunity bill. Effectively, we created a new section, 76838, and we basically made an immunity concept, limitations of liability from a claim related to COVID-19. We set a statute of limitations for these claims at 1 year, and it actually has a retroactive component to it, so it may even be shorter than a year. In order for somebody to bring one of these lawsuits, they've got to have a good faith, substantial compliance with government health guidelines. It's a really tedious process. The one item I want everybody on this one to know was something that flared up at the end of the session, was a question with the definition in the statute tying to 6603 of whether limited liability companies were covered under the COVID immunity legislation. And in some of the late communications with those in the industry that were responsible for bringing this forward, it seems that limited liability companies are out. And so we noted the definition that they tied to for business entity, which does not mention limited liability company. So for those of you that are entities that do business as an LLC or associations that have a lot of vendors that are LLCs, be cognizant of the fact that the COVID-19 immunity bill at this point does not seem to reach them.
So I want to kind of interrupt just for a second because I know I've been getting a lot of questions from associations concerning, how they can make sure they can take advantage of the immunity legislation, providing for complete, insulation from a lot of the claims and a lot of the stuff that we've talked about through the last year on many of our webinars, which have presented, a lot of risk and risk management type matters for associations. And I keep getting, questions concerning how exactly we can make sure that we can take advantage of this. And from my perspective, you don't throw your hands up and say, everything is open and COVID didn't exist here. That's not how you take advantage of it. You still have to have good faith compliance with government issued health standards. But Shawn, it's complicated because those things keep changing. So do you have to comply with, all of them? The local ones are kind of gone at this point. Can you give a little more detail there or any other thoughts?
I mean, the law is set up is you get to pick the health standards you want to follow. And note that it's good faith, substantial compliance. So it means if you look at whatever the health guidelines are in your local area, if you pick the state or the CDC, you don't have to check the box in every single one. You have to just make basically a good faith effort at compliance. And if you do that, they literally basically are going to have to show that you tried to intentionally infect people with the disease in order to establish liability. So as long as you can point to a set of health standards that are government issued from somewhere, you're going to fall within the parameters of this statute based on this intent.
So from my perspective, if associations continue urging their residents, guests to comply with any CDC recommendations and that they somehow keep their guidelines in line with those recommendations, that seems to be, a good way to comply with it to me. Seems to be a good way to comply. Okay, next, more COVID-related legislation.
Is vaccine passports, Senate Bill 2006, which, if you note, is now number 8, 2021-8, which means the governor has approved this, and it is effective July 1, 2021. And this is the legislation we all heard about recently when, in tandem with it, the governor issued his emergency order eviscerating all the local controls.
So let me interrupt again, because that's what I like to do. I just want to clarify that the immunity statute we already talked about is already approved by the governor, effective. It's there. It's already there. This vaccine passport law was approved by the governor. It is law, but it's not effective until July 1. So what will it say?
Most of it is geared to the state preemption of local government emergency orders. And so you can see with what is there, any political subdivision, so those are your counties and your cities, that deprive rights or liberties of an individual or business must show the order is narrowly tailored, serves a compelling public health or safety interest, and is limited in scope, duration, and applicability. And what's important even more is that the local government orders expire after 7 days and that there's a cap on 42 days. And there's other things in here that are referenced in the materials. You can click on it and view the bill. There's the presumption that schools and businesses should remain open during these period of times. The governor gets some powers in order to basically invalidate by his own decree local government restrictions. In terms of our world of community associations, if you recall, literally just a couple of minutes ago, we talked about the LLC issue when it related to the immunity and that they weren't in. Well, here, when they tried to address the issue of requiring proof of vaccination, i.e. the vaccine passports, they used the same definition of business entities. And so they said business entities cannot require customers to provide documentation showing vaccination against COVID-19 to gain entry or service to the business. We've all heard that. But we have the LLC glitch here, which is, again, they're not covered under that definition that ties back to the COVID immunity bill. So you have a situation now existing where an LLC is not covered under COVID immunity, but is exempt from the requirements to comply with the vaccine passport. The other larger issue is, does this apply to associations? If you look at 76838, it includes the definition of nonprofit corporations. So the consensus generally is an association is immune from the COVID claims, but this vaccine passport arguably applies. The association is one of the covered entities, but then from there it sort of diverges because it talks about obviously entry or service from the business, and that doesn't exactly fit with the association. So we're sort of putting this on your radar that it may or may not apply, but you're going to have to be aware of this. And obviously, as you want to acquire proof of vaccination, we highly recommend that you consult with whoever your counsel is in context with this law.
All right, now we'll get into some non-COVID related issues. This is a bill that was, I believe, sponsored by the Department of Business and Professional Regulations. We all know it as the Division of Florida Condominiums because that's who we deal with. Senate Bill 1966. That is will be effective July 1 if it is signed by the governor. And why we wanted to really do this course today for everybody here is that a lot of these laws, as we've mentioned, will be effective and will be there as of July 1. So we're already May 13 right now. It doesn't give you a lot of time to prepare. So we thought we need to tell everybody about these laws. You know, all, of course, COVID and everything aside, some of the stuff is operational and you need to incorporate it into your plan for the rest of this year. So that's why I felt very strongly that we needed to do this right away, not to hold off, because July 1 will be here before we know it. So in terms of what's relevant to condo associations, again, this is condo specific, everybody out there, condo specific. This new bill is very interesting. It changed eligibility for the board. So if you have your annual meeting, you know, shortly or upcoming, obviously we don't see that many during the summer, but I know that they're there. You need to know about this. It's very interesting. Condo law will be changed effective July 1 to say you cannot be delinquent in an assessment to be eligible for the board. The state of the law currently right now is that by the date you have to submit your notice of intent to be a candidate, the due date for that, you cannot be delinquent in any monetary obligation owed to the association. That would include fines, that would include lost key card pass fees, that would arguably include, you know, damage that the owner caused to the gate because they ran into it on their way into the garage. So there's now been a change specifically to establish eligibility only. Now the law is going to provide as of July 1 that you cannot be delinquent in an assessment. It has removed this other monetary obligation component. So in terms of reviewing candidacies, when they come in the notice of intent, you only look to assessment. This should be very interesting to see how this plays out, because I know a lot of the amendments that we write and that I review say that certain fees are considered an assessment. So will that, you know, be towards your eligibility component? I think probably yes. I think it's very interesting also that this type of language is used so many other places in the statute, where you say if somebody's delinquent or more than 90 days delinquent in a monetary obligation, fee, fine, or assessment, then something can occur. There's a trigger. There's also, you know, very interesting to this specific issue is that in the Condo Act, once you get on the board, you cannot be more than 90 days delinquent. If you become more than 90 days delinquent in the payment of any monetary obligation, you're deemed to have abandoned your office or your board seat, creating a vacancy to be filled per law. So here we have a situation that you possibly could be delinquent, let's say in a fine, get onto the board, but once you get on the board, if you're, for instance, more than 90 days delinquent in the fine, then you're deemed to have abandoned the office. So there's a problem here, and we'll see how this plays out, but be aware of the distinction. They'll change in the law. Don't keep people off the ballot for being delinquent in, let's say, fines, because in a condominium, if you keep somebody off the ballot, then your election is jeopardized. So this is an area, come back to this, talk to your attorney about this. It's an interesting distinction. I definitely foresee that we'll see some issues here and some trouble, because it doesn't really seem to make a lot of sense in a lot of ways. The second thing that the division added here, for condominiums only, by the way, is a new requirement that the board adopt your annual budget no less than 14 days prior to the end of the fiscal year. So typically we'll see the fiscal year January to December 31. You have to have this board meeting to adopt the budget 14 days in advance of the end of the year. If the board fails to do that, the statute does provide that the previous budget will remain in effect until the new budget is adopted. And the statute was specifically addressed to deal with Division of Florida condominium fines. They are very apt to fine these days if they see financial violations, such as not adopting budgets or not budgeting properly. So we have a specific provision saying that if you fail to do this, it's deemed a minor violation by the division, until it's occurred twice. So you have one get out of jail free card, and then you will be fined, and the fines are pretty steep. They can be $500, $5,000. It varies, but this is something, once again, to watch out for towards the end of the year. You just don't want to have to deal with a complaint in this area.
Assessments, the joy. Senate Bill 56, and one lesson we all learned is be careful who you send your collection notices to. You never know when you're going to hit a sitting member of the legislature. So what did we do this time? Well, it really wasn't something we did. It was more driven by the legislature. So we changed this. So now account statements sent out by an association must be sent by mail or email to the address maintained in the official records of the association. Where it gets interesting is an association may not change the method of delivery without a 30-day written notice to the address of record. And then that owner must affirmatively acknowledge the change in delivery. And then that affirmative acknowledgement is an official record that's not available for inspection. So if you want to change the address, you have to have the owner effectively say, yes, please do. And then I guess a simple form that's, check yes or no if you want us to change your address is now an official record that you can't see. Where it became even more problematic was the statute now incorporates across the board for 718, 719, and 720 a mandatory courtesy notice 30 days before collection action. I know a lot of associations and the management companies send out the courtesy notice. It's now statutorily created, and it has to go 30 days before you can proceed on anything. And the notice is very clear. It's in the statute of forms there, and the only 3 line items that are listed for the recovery are assessments, interest, and late fees. Nothing else. And the statute is specific that you can't seek attorney's fees or any of these other collection costs until this notice goes. There's an affidavit of compliance that's required to establish a rebuttable presumption the courtesy notice was sent. This is designed in the event that you get a challenge from somebody saying, I did not get all of this. What's even more problematic is we've always joked about we need to harmonize all the statutes. Well, the legislature took the liberty of doing that for us by harmonizing all collection notices with a 45-day deadline. So the condo and cooperative ones that we're used to with this 30-day notice on July 1 are all shifting to a 45-day notice. So if you're out there in association land in 718 or 719 and you've got collections pending and don't feel like having to get hung up in this process, I would encourage you to move those collections fast, because come July 1, if you haven't taken collection action, then you've got to send a courtesy notice. And if you have, you're now going to have suddenly these 45-day deadlines popping into your world. Really, it's just at this point, I would encourage everybody, if you can get ahead of this before July 1, do so. Otherwise, you're going to end up in some ways maybe in a test subject on a lot of how this statute applies and how the defenses are going to shake out.
Yeah, and this is an interesting one because I feel that the associations with management companies will fare pretty well here. All of the management companies will get up to speed and they'll offer these courtesy notices, and hopefully they'll all be correct and all of that. But I feel that for those of you who are self-managed by your board only, could be more difficult for you to deal with. So once again, this is something that I draw your attention to tell you that this exists. You have to deal with it. Get with your counsel to talk about how you can best deal with this type of matter. Somebody did ask on the question, I thought it was a good question, the affidavit that we mentioned, does it have to be signed by the community's manager? It says that it must be signed by the board member, officer, or agent of the association, or a manager. So it's basically whoever provides the notice has to do the affidavit. It doesn't have to be simultaneous. It just has to be there to go forward with the collection if you need to. Correct, Shawn?
That is correct.
Okay.
This is also going to take care of an event. Miss the courtesy notice. In theory, you could blow out the entire collection action once you're way down the line.
Yeah, that's the concern that us attorneys have here, is that now this courtesy notice becomes a precondition to pursuing your collection action. So we have to review it as the attorney and make sure it's correct before we can go forward with anything else, because if it's not, as Shawn just mentioned, then it could jeopardize your case at a later time. And that's why it is very, very important. Okay. Now we're moving to another large bill. This is Senate Bill 630. This is really, what is it, 101-page bill, and it includes much, a lot of meat here. We haven't seen a bill like this for a number of years, Shawn. I'd say like 5 or 6 years. We have not seen this much come down. An interesting question I saw on the chat as well was, who's responsible for getting all these laws changed all the time? Why do we have to have all these law changes? That's a larger question that we can answer. But a lot of it is lobbying groups, and a lot of it are, groups to try to clarify problems that are already there. Some people have their own interests. Like Shawn mentioned, we are very active in the Florida Bar's Condominium Committee, and we try to review all of these bills, but most of our work is technical. We don't have a lobbying group, and we're not there to promote certain interests, but that's typically how it will work. We have this big bad marshmallow man walking in with all of these different laws now. And again, I just will mention, this bill is not signed by the governor yet. We don't expect that it will fail. We do expect that it will proceed to become law on July 1. And again, I've said it like 10 times now. That's why we're doing this course. July is coming up very quickly. So first thing on the list to talk about was Senate Bill 630. And in the outline, you have links to all of the specific bills which contain all of these provisions. So if you want to click on the link and go read the 101-page bill, I encourage you to do so for your homework tonight. So first is condominium insurance. This is a kind of a big deal. This is regarding subrogation, and I will just read the new law because it is one sentence. It says, if the association's insurance policy does not provide for the right of subrogation against unit owners in the association, an insurance policy issued to a unit owner may not provide rights of subrogation against the association. This is a situation that many of you condo association people have probably dealt with in the past 5-6 years. You'll have an issue and an owner will make a claim with its insurance company. The owner will be paid out by the insurance company, and then the owner's insurance company will subrogate, step into the owner's shoes and sue the association for some type of negligence or some other type of action to recoup the monies that they paid out to the owner that they felt were the association's fault. So this is somewhat putting a stop to that. I don't know if any unit owner policies will have this right because the law essentially makes it too difficult. This will possibly create some issues in the insurance marketplace. We will have to see, but it's very interesting to see how this will play out. And it is a very short change in the law, very brief change with a lot of potential impact. That's what I'll say about that. Condominium official records, next topic. Again, specific to condominiums here, law was clarified to provide that you have to keep bids for 1 year after your receipt of the bill. Law was clarified to provide that tenants can make a records request only for declaration amendments, bylaws, and rules. And the law was also clarified to provide that you don't have to have a purpose to inspect records. All condominium unit owners have the right to inspect the official records other than those that are not accessible. So that is really all of these are kind of clarifications except the bid issue. A big deal is term limits, condo term limits. I can't believe it was back in 2018 where the law was changed to say that and again, condo only here, that you cannot serve 8 consecutive years on the board. That was in 2018. As you probably heard in like every course I've had on a webinar for KBR, that our position was that law applied prospectively going forward, that your prior service before 2018 did not count towards the 8 years. And I've also said, the 8 years doesn't even apply if 2/3 of the owners vote for you in the election, or if your service is not consecutive, right? So finally, now in 2021, we have a codification of this, that the law really does only apply prospectively from July 1, 18 going forward. So now we can all point to the statute and say that the term limits don't begin to run until July 1, which is nice, which is what we all thought anyway, but now we can actually point to something black and white. Here you go, 718, 112 to D, and there it is. Notice of membership meetings for condominiums only. Once again, condos, the law was kind of clarified here. This is not a big deal. This is nothing like star this page, you know, be careful. This is a clarification that your annual meeting notice must be sent and posted at least 14 days in advance, and a special meeting notice must be sent in accordance with your bylaws. If your bylaws don't provide for a notice period, then it has to be sent and posted 14 days in advance as well. So that's somewhat of a clarification, not the biggest deal in the world. Okay, but this really is like a big deal to everybody. This condominium transfer fee increase, we are going to see an increase on the next slide, but I'll save that a little bit to give, you know, the backstory on this. As long as I've been practicing condo law, I've heard from many clients, many industry professionals, many of my peers, that this $100 transfer fee is just frankly too low. The cost of background searches or other, you know, searches that you have to incur, fees, don't cover the cost. And we've been dealing with this for a really long time. And finally, we were able to get an increase in the transfer fee. Transfer fee is now increased from $100 per applicant to $150 per applicant. We got a $50 increase after, I don't even know how many years this went in there when, you know, when this originally was put into the statute, but I'm going to go figure that out. Actually, it's been, I don't know how many years, at least as long as I've been practicing, and we finally got a $50 increase. I will remind everyone, highly important to remember for condos, you cannot charge a transfer fee unless you have the authority to approve transfers in your declaration, presumably. You don't get to charge a transfer fee unless you have a right of approval. It's a precondition. Also remember that the $100, now $150, is per applicant, but spouses and parents, dependent children are considered one applicant. So if you have a spouse situation, you may only charge the $150. It's not $300. That you cannot charge the fees for the renewal of a lease with the same people. The statute doesn't allow that. And the good part about the new law is that the transfer fee will also increase over time, not substantially, but it will be able to travel with time. We won't have to wait another 15 years to have a statutory amendment to increase it. It must be adjusted. That's what the statute says. It must be adjusted every 5 years according to CPI. So we will see increases from time to time here. Okay, next topic, condominium charging stations. And this is an interesting addition to the statute. We have some changes related to electric vehicle charging stations, but we also have a new provision of law that, similar to electric vehicle charging stations, now natural gas fuel stations are also going to be authorized in condominiums. Again, condominium specific here. The change in the law, in addition to allowing natural gas fuel stations, is that previously you could only install the electric vehicle charging station in a limited common element parking space. And that's a very specific term. It's a very specific analysis, and we can determine whether something is a limited common element or not. Now the law has been amended to say, in addition to being able to install in your limited common element parking space, you also will be able to install in the exclusively designated common element parking space. So this gives owners better rights to install the vehicle charging stations in any space which they've been assigned. I foresee some trouble there because the terminology isn't as tight as we would like it to be. So I could see it's like, well, is it my assigned space or is it not my assigned space? Is it not my assigned space? That's kind of to be determined. Also, in addition here is that an association can install an electric vehicle charging station, natural gas fueling station on the common elements or association property, and it's not considered a material alteration of the common elements, which is actually pretty cool here. You have a lot of people in your condo with electric vehicles up and coming, and they want this. You have the option to do this, and it's not considered a material alteration that could otherwise require a vote of the general membership. I will say, and I know Shawn probably has comments here because he was involved in the initial law that came into effect a couple of years ago regarding electric vehicles, that sometimes, and you all on the Zoom today might know, because you're on the ground at the properties, that the properties sometimes are not set up for these facilities, that you just don't have the power or the energy sources to allow you to have multiple electric vehicle charging stations. And now I can foresee the natural gas fuel station needing, permitting and licensure issues. So, it's nice to have this here. And I think many people have been able to take advantage of it. And it's great because this is the future, obviously, but it's practically difficult a lot of the time, I suspect. And the owners have to incur a lot of the responsibility here to install, to get everything permitted, to kind of figure it all out. The association's somewhat along for the ride and has to allow it under certain conditions. But if you're an owner, you kind of have to figure it out. And sometimes it might be futile because what's there on the ground is just like not set up for what you want. Shawn, any further thoughts there?
I mean, my opinion to this would be, given the way the natural gas setup is generally in a lot of communities, we have an open question of whether or not this is going to permit owners to effectively install tanks underneath their limited common element space or wherever their assigned space is. And, having done work in terms of, sale of things like gas stations, the environmental aspect of this actually becomes a very huge deal. And ironically, when we were dealing with this in the legislative session, somebody made a comment that we were effectively going to allow owners to bury bombs throughout the parking lot because, well, natural gas tends to be that way. So there's a lot of open questions on this. There's also the added component, if you have charging stations for electric vehicles, what are the odds of the fire marshal permitting the installation of a natural gas fuel line running next to that? So we're going to see this unfold in a very interesting way. And, I think, again, back to the comment of how stuff gets passed, you have to remember that one of the people in the legislature's family is in fuel, natural gas, and those type of fields. So you can see where that interest comes from. So this is one that I'm going to pay close attention to, because when somebody wants to trench the parking lot to put in a tank, we're going to have an interesting conversation.
All right. Yes, practical difficulties there I foresee, but well intended, right? Investigations by the DBPR, Division of Florida Condominiums, another power that they have now been able to grab here, that in addition to being able to investigate complaints regarding access to official records, the division now is able to investigate complaints, once again, condo, I believe in co-op here, not homeowners associations. Division does not have investigative authority over homeowners associations, but now they've amended law to say that they also have the authority to investigate complaints regarding the maintenance of official records. To me, maintenance of official records means that you're not keeping records that you were required to keep. The law was amended a couple of years ago to, let's say, you have to keep minutes in perpetuity. Maybe you're not keeping them in perpetuity. Maybe you're throwing them out after 7 years under the old law. So, it's just additional authority for the division to look at unit owner complaints regarding record access issues. I'll say, earlier in this year, we saw several bills out that died, that were very burdensome for associations concerning record access issues. The division had put out something that would have required, the associations to keep records in a certain manner and give affidavits concerning whether they've complied with records requests and have some kind of a checklist. That did not go forward. It was very burdensome, and I could see associations having a hard time with that. But we did get this change. I will say that records issues are pretty huge, emerging issue in terms of division of Florida condominiums. I think that going towards, digitizing records is where they would probably like to go in the future. It's hard to really deal with that universally because not all associations are the same, have the same resources, have the same volume of records. So it's just not an easy issue to figure out, but it is something that I see continuing to be tweaked as years go by. This is the new law. Be aware of this. You could get letters from the division concerning record access and maintenance issues that maybe you hadn't seen before. So don't be too shocked about that. Another brief addition to the statute was regarding the Condominium Ombudsman. This is the sort of overseer of all of the Division of Florida Condominiums, attorney appointed by the governor who serves the people and is supposed to be sort of a liaison between condos and other governmental agencies and groups, and trying to promote unit owner and association rights. The office was, per statute, the principal office was required to be located up in Leon County, up by Tallahassee. It kind of made sense a long time ago. Now we have the statute amended to say that the office can be wherever is conveniently located. Our current ombudsman, Spencer Hennings, is in Broward County. I believe he's over in sort of the Aventura area, but he's out of the West Broward office, I believe. So, all of us are remote right now. Why can't the ombudsman be wherever they believe is the most convenient for their service? I could see that. Oh, this is a big topic: condo and co-op arbitration, pre-suit mediation. Once you have a dispute with your owners, once you have a dispute with your association, we were typically used to, for a lot of disputes in condo and co-op world, going to condo arbitration, division arbitration. But now you have some new options. So this is kind of cool that, you're not required to do one certain thing now. Shawn, you were a big part of this.
Yeah, I guess you can say this was one of the items, ironically, that, usually the bar does not have policy, but this was an initiative that came out of the real property section, the condominium committee, to basically say, look, the arbitration system was a broken, non-functional system and try and fix it. And so we had it in 2019 to address it. That legislation died. We had it in 2020 to address it. That legislation died. And in 2021, we finally get something that hopefully the governor signs and comes through. So what did we really do? It's a subtle change. It's not as far as, if you look back at the 2019 version, it goes nowhere close to it. But now, instead of having to take disputes in condominiums and cooperatives that you had to file with the division, you can now utilize the pre-suit mediation process available for homeowner associations under 720-311. So you effectively get now to make the choice. Do you want to do a petition for arbitration with the division and go through that process, or would you rather exercise the pre-suit mediation process? It is a pick your poison, for lack of a better way to put it. And this was actually signed off by the division. They approved this sort of option. So the party that brings the action will get to make that election at the beginning of whether I want to be in the division format and go through that, or whether I want the pre-suit mediation. And if we don't resolve it, then we go straight to circuit court. And so what type of disputes can get affected by this change? Failure to properly conduct meetings. The big one that Allison was highlighting is inspection of official records. We may actually get some official records cases in condominiums if we go mediation and then we litigate it and somebody takes it up on appeal. We may actually have guidance on it. Altering or adding to common areas or common elements, or requiring an owner to take any action or not take any action involving the unit or the appurtenances to the unit, which we could see maybe potentially flare up when we get back to our charging stations or electric vehicles. This is one of the larger fundamental changes, and I'm happy that it's come through, because I think the arbitration process tends to be not as what we want it to be politically correct. And so the ability to go to pre-suit mediation, sit down, have that conversation, figure out if there's a deal to resolve it. If not, then we just take it straight to court and get this thing going. This, I think, is one of the more fundamental changes that's going to be beneficial to associations going forward, to be able to not be stuck under the arbitration process. And then if you don't like the result, having to try the case effectively twice.
All right, let's see. Oh, more remedy situations specific to elections and recalls here.
Yeah, so in conjunction with the initiative to replace arbitration with pre-suit mediation was also the issue of what do you do with recalls in elections, since those have an arbitration component across the board, condo, co-op, and HOA. So that still exists. The arbitration component still is there. However, election disputes and recalls now, instead of going straight to the division, you can go straight to circuit court instead of arbitration. This will be interesting to see how it unfolds, because one of the original items in the legislation from 19 included what is a summary proceeding, which is in the estoppel statute, how you would challenge it, which requires these things to move faster. That didn't make it through in all the different versions that have been killed over the years. So you sort of end up in regular litigation land with you file the complaint, 20 days to answer, and all of that. So it's going to be interesting to see how this plays out strategically with election disputes generally given priority. But now if you want to make an election challenge or a recall issue, you don't have to deal with the division. You can elect to go straight to court and have the court determine what the ultimate result is.
I'll just mention here that just keep in mind that you have to challenge an election within 60 days of the date the results are announced. So I just like to throw that in when we're talking about election disputes, to keep that in mind, that after the 60 days, you're kind of done. I think that would apply to arbitration, court, wherever it goes. Shawn?
Yeah, the 60 days still exists in the statute as effectively, that's your statute of limitations. And so if you miss that, then sorry, even if you have a fantastic case, we're not going to be able to do anything with it.
Oh, emergency powers. And, we talked a lot about COVID related issues, the state's authority, local government authority, all of that at the beginning of the program today. But this is specific to condos, co-ops, and homeowners associations in the emergency powers statute that we're, I suppose, still looking to a year plus later, because our state of emergency is still ongoing. I'll mention that Shawn and I both served on the emergency powers task force, I can say that, of the Florida Bar. And we're tasked with reviewing all of these statutes and making recommendations. And, my recommendations, the statute is not the dream of what I would have wished it to be. We do see some clarifications, but we also see some limitations that Shawn will talk to you about.
And when you're dealing with not just associations, and Allison and I advocating for there, you have Florida realtors, you have title agents involved with closing, you have the managers, you have CAI. So there's as we call it in legislative land, there's the condo gaggle that attacks these bills, and there's all these different aspects to it. And so you end up, generally with something that works, and you hope that everybody signs off on it, so you don't have somebody like the Florida realtors willing to kill the entire 100-page bill because the language in emergency powers was not quite what they wanted to address their issue. So what came out after this adventure in this past session? So emergency is now tied to a defined term in the Emergency Management Act. And conveniently, when they passed Senate Bill 2006 and the governor signed, which will take effect on July 1, it added in multiple new definitions regarding pandemic and those types of disasters. So those now are going to slide into emergency powers and be covered under that. The law allows board and committee meetings, election member meetings to be by phone, real-time video conferencing. We've all learned Zoom. I wish I would have bought Zoom back in February of 2020. I would be a much happier man with this day. Notice that, these may be done by electronic transmission. And, a big one that came through, and, I'll give props to Allison on this one of sort of highlighting as through the bar process, was that also allowed the decisions to be communicated as provided. So if you're emailing out, these notices of meetings, then you could email out, hey, this is what happened. It allows to restrict access to common areas and facilities based on the advice of public health officials. And a big one that made it through was mitigating damage or the contagion, i.e. the pandemic, by removing debris or sanitizing and being able to pass on the cost of sanitization to the party that's responsible for the association incurring it. But as the legislation gives, the legislation takes away. So we have limitations on power to address some legitimate concerns that came up during this pandemic era. So an association cannot prohibit owners, tenants, guests, or agents from accessing the common area and facilities for ingress and egress to a unit, i.e. you don't get to lock the tenant out because they left. If it's their home, they get to come in and out to the unit. You can't keep them out. You can regulate where they go, but you can't keep them from getting to their unit. And we allow access when necessary for it's the sale, lease, or transfer of title. That was a big one of the real estate and title industry, that they have these deadlines in their real estate contracts that require inspections within a period of time. And if they don't, then the buyer has to make an election, cancel because I'm not satisfied with the condition, or if I don't, then I'm committed to buy. Note that this is only when you have to deal with the sale, lease, or transfer and the inspection. This doesn't mean that if you're locked down, they get to go wander around the pool. The pool is irrelevant when it comes to transferring title. It's stuff like plumbing, air conditioning, and the like. We also have added access necessary for habitability of the unit or parcel. So if you're on the 36th floor of a high-rise in August and your air conditioning goes out, the air conditioning repairman can come into the property and fix it. Also, for those that are homebound and getting the delivery of medicine or groceries, this was designed to pick that up. And finally, we have also access is necessary for the health and safety of person. That was, another one that was needed to be addressed. There is also that it's subject to limitations on access from the CDC Public Health Directive. It's kind of funny that got through because you have the COVID one that allows for any health directive, but here emergency powers tied specifically to the CDC. And of course, with all of this, associations still have the right to pass rules on access. So as long as you're not absolutely restricting access and compliance with the statute, you can regulate how it comes and goes, how that access is gained.
Yeah, I would just like to highlight that, while we can't keep people totally out as an association, and that makes sense, right? In a lot of ways, all of these restrictions concerning, people you have to let in, it all hinges on whether the activity is necessary. You have to have necessary for the sale, lease, or other transfer. It's just not because you feel like it, not because it's desirable. You have a contract, purchase and sale contract that shows an inspection period and that you have to get your deal done. Okay, maybe that's necessary. Your air conditioning broke. You have to have a vendor out there to repair it. Yes. Okay, that's necessary. This isn't going to be, in my opinion, it shouldn't be a free for all. And as Shawn mentioned, the last bullet point on the slide, that you can still adopt reasonable restrictions. So while you can't prohibit owners from getting to their unit, tenants from getting to their unit, you can have logistical restrictions concerning you have to use this pathway, this door. Maybe you even get to have hours for realtors to do their business, that they can only come on Tuesdays and Thursdays from 12 to 4. It has to be a reasonable restriction, and that's always debatable what's reasonable and what's not, but you still have some control over these factors. And it's not that you can't do anything. You still can have reasonable restrictions. So don't don't get too frustrated here that have to allow for all of this stuff in our future, hopefully never additional pandemic, but there are the limitations at this point. Co-op, anything else on that, Shawn, before we leave that topic? It's such a big topic.
Okay. And that gets
it's a little hard to hear you sometimes, but we'll just, if you want to pipe in, please do.
That the whole emergency powers in the declared state of emergency, and whether that gets renewed in June is obviously going to be an open and spirited discussion.
Yeah, that is important to point out. We're still under the state of emergency, but we keep saying every time we come on these Zoom chats that, it might not be renewed, and that will be interesting to see how this all plays out, whether associations will continue to have safety restrictions or not, and the enforceability of those. Yes, correct. Back to this now, for those co-op members, managers who are on the Zoom today, we did have several updates to the co-op statute by virtue of Senate Bill 630. We're not going over all of them today because they mirror a lot of the current condo law. If you're a co-op person, please visit the bill link in the materials and re-review the updates to co-op. If you're a manager, this will probably be very familiar to you because it's frankly moving things from condo law that have been there for years into co-op. One I will highlight here that's a nice addition that I like to say, something we can point to say that this is what it is. Co-op board members and committee members can participate in meetings remotely, by telephone, by Zoom, by other real-time conferencing methods. That just was apparently not in the Co-op Act, and with everything going on lately, this is a very good addition. Okay, HOAs, we finally got to you. If you're an HOA member, manager, we finally have some specific items that deal with HOAs. If you're a condo, this does not relate to you. The HOA Act, as many of you may remember, was amended a few years ago to say that rules and regulations were included within the definition of a governing document. Well, okay, why does that matter, Allison? Well, that had a lot of consequences to it because the HOA Act has many instances where it uses the term governing document. So I'll just highlight a few. And the point of this slide is to say rules and regulations are no longer considered part of a governing document because it didn't make sense and it was causing a lot of trouble. One of them that we've discussed many times through the past couple of years is a recording requirement that everybody knows when you do an amendment to your recorded documents, your declaration, your articles, and your bylaws, you typically have to, you have to record it in the public record, that you have to go send us a check for recording. We go record it with a certificate and we send it to you saying, we've recorded this, it's all good, it's legit, everybody's on notice of it, who goes and looks in the public record. The law was, then we had to deal with rules and regulations being recorded in the public record when they typically never were before. So that was a bad consequence of having rules and regulations as part of the definition of governing documents. So a result of this is you no longer have to record amendments to your rules in the public record. That's good to me. That was kind of burdensome for associations. There are also other instances where the term is used where it just like doesn't make sense. There just comes to mind that the HOA Act said that board members cannot be compensated for their service on the board unless provided in the governing documents. Well, we don't want a board rule authorizing payment to a board. That doesn't make sense. So this was a very good addition. It cleared up a lot of the technical problems that we had in the statute. And for you, what's relevant to you, I would suspect, is that you no longer have to record amendments to your rules in the public record. So that cuts down on administration expense. Frankly, recording is not cheap. HOA official records, there were several changes here. I'll try to run through them quickly. One of the good changes was that now you only have to maintain voting material for 1 year, similar to condo law. That is the law for condos for a long time now. It previously was silent really on a carve out for this type of record, which meant that you had to keep all of the ballots, proxies, envelopes, if you use those, for 7 years. That's a really long time to keep that volume of paper, right? And sometimes that stuff's hard to get scanned in because of the condition that it's in. So this is a good change. Now you only have to hold it for 1 year rather than 7 years. Very interesting change, not related to condos, once again, not co-ops. This is homeowners associations only. New item that is not available for inspection by a member or their representative. You have to keep this type of thing as part of your official records, but is not accessible to other owners or their representatives, is information obtained in a gated community in connection with guest visits to owners or residents. If you have a gate at the front of your community, manned or unmanned, and it has keeps record, or you keep record of who comes in to visit your members, those guest visitor name, access logs, history reports are not accessible to other owners and residents. We've had instances where this has been requested through official records for some clients that I've dealt with. I can understand how it presents sensitive issues on many levels. We can, imagine that you don't want your neighbor or who's down the street knowing every single guest that comes to visit you for various reasons. So this is interesting. It just kind of got stuck in there. I hadn't heard about this, so that's why it kind of interests me more than others. Again, it's HOA specific. It does not relate to condos or co-op members. HOA reserves, I'll run through this pretty quickly. It's highly technical. Many changes here. As you may remember, the rights of homeowners association members are kind of being eliminated over the years. You'll remember that warranties for HOA associations and lot owners have been kind of eliminated over the years. Reserves required by developers who create these HOA communities have been limited over the years by virtue of case law that has come down here. And now finally, we have probably the home builder lobbyists further revising the statute to limit the amount of reserve contributions that they need to include for their communities. We have now the law, the state of the law is basically HOA reserves are only going to be created by a vote of the membership. What are known as statutory or restricted reserves for a HOA community are only going to be created by a vote of the membership and not as initially established by the developer. The developer can establish reserves if they want to. They can partially establish reserves. They can fully establish. Will they? Probably not. but they can do so, and it doesn't get them on the hook for continuing to fund reserves forever. So the law has further limited any developer contributions. You'll read in the statute, it also further limits other obligations of developers for, other types of expenses. And this is just going to be the state of the law going forward, that HOA reserves are very limited. If you're an HOA association and you want to have restricted reserves that are going to be there years down the road because they're administered properly and in accordance with the statutory reserve scheme, you need to get with your lawyer to make sure that you have the reserves that you think you have. Because a lot of times associations, homeowners now, think that they have these restricted reserves that will be there at a later time, but they really only have unrestricted reserves that the board may or may not be able to use sort of like as they see fit. So this is an area I feel very strongly about, that you need to go check with your attorney, your accountant, to figure out what type of reserves you have and possibly take a vote of the membership to convert them to a type of reserve that is highly restricted and can't be used for other purposes without the vote of your membership. So I've spoke enough about that. But moving on to another very important topic, HOA leasing. Again, if you're an HOA board, if you're an HOA person out there, owner, board member, manager, this really is a page where you want to star the page. You want to probably come back with this. You want to share this with all of your other board members. If you're a manager, really pay attention to this. The law is going to be changing to limit the right of a homeowners association to restrict rentals. This is very similar to the condo law that we've all lived with for a long time now, for probably 13 years, concerning amendments to a document that affect leasing. Here, the statute is a little bit different than the condo law, but effective July 1, your community will not be able to have an amendment that is going to regulate leasing unless the owner consents to the amendment or somebody acquires the parcel after the amendment becomes effective, right? So it's very similar to condo law. This is a grandfathering thing that's very oversimplistically, new leasing restrictions will only affect the people who consent to them and the people who come into the community afterwards. However, we do have a few exceptions that aren't in condo law that are actually pretty helpful here. That law, that does not apply to restrictions that regulate rentals for a term of less than 6 months or prohibit rentals for more than 3 times in a calendar year. So essentially, you can still have short-term leasing restrictions that apply to everyone, and there will be no grandfathering. I will also mention another exception. If you, let's say, amend your documents to provide that there is no leasing, you will have no leasing, but owner A, ABC Inc. did not agree to that amendment, so they were not bound by it. They can still lease out their unit. Well, ABC Inc. is a conglomerate and they deal with like 10 different entities that are an affiliate, and for purposes of their business transactions and profitability, ABC Inc. transfers the lot to, XYZ Inc. It's their affiliate. So in that case, the affiliate entity, although they are a new owner, will still not be subject to the restriction. So there's an exception for changes of ownership for affiliate type companies. There's also another exception, the last bullet point on the slide, for heirs, for your family members of deceased owners will not be subject to the leasing restrictions that were imposed. I think the heir situation is interesting. I foresee that we will have leasing restrictions that are attempted to be enforced against certain individuals who will come out and say, oh, I'm the heir of the prior owner and therefore it doesn't apply to me. Well, proving that you're the heir and all of that should get a little interesting. I'm curious to see how that will play out and the number of disputes that we may see concerning really like a probate type matter that we don't typically see in association world, because we're not talking about who's the heir of who, sometimes we do get into that, but now we have it right here in the statute regarding a leasing issue. Leasing issues come up all the time. So I suspect we will see that. Okay, another topic, property insurance. There's a lot of insurance changes on property insurance. We just wanted to briefly mention that this change is there and could have some impacts on you.
Well, but dive into insurance, I wanted to circle back to the leasing to make 2 points, or a point and a question. First was everybody sitting there staring, going, what in the world? This was one that was such a priority of leadership in the legislature that it actually had its own standalone bill just for this that was lined up to pass in case the whole bill that we've been talking about here, 630, failed. So you can see the priority. And the other one, Allison, I think is a practical point is, do you think that if we want to cut all this off, we have to get our amendments done and recorded prior to July 1 if we want to circumvent the law? This is sort of our 6-week window of opportunity to save our rental restrictions.
Yes, that was, the main point here, going back to what I've been, complaining that everyone needs to get ready for all of this, be ready for these changes. But Shawn's completely correct. The point of this is if you want to have leasing restrictions that are applicable to everybody, notwithstanding whether they consented or not, you have the opportunity to get that vote out up until July 1. So if you have no leasing restrictions and you've been thinking about this is important to you, please get in contact with your attorney immediately, because, we have to prepare the amendment, you have to schedule a meeting, you have to have time to approve this, you have to get the certificate of amendment recorded, as Shawn mentioned. So this is not something that you want to mess around on if this is of interest to you, because you could be partially shut out after July 1. We do have the exceptions here for short-term leasing, but they're not that, it's just a minor exception. All right. Anything else on leasing?
No, those were
okay. I think I emphasized the importance.
So property insurance.
Back to property insurance.
It's in more detail in your outline. This is just a summary to kind of blast through it quickly because it's an item that was out there, and it was a high priority in the Florida Senate this legislative session, priority of leadership to get through, and conveniently or inconveniently, they basically have said that this only gets about 40% of where they want to go with property insurance. They really want to come back and ratchet it again, so we'll see this again in 2022. But really was an effort to address insurance rates and fraudulent claims. It's, again, more detail in your outline, but it prohibits certain practices by contractors and public adjusters and those working on their behalf, i.e. inducements to hire them and have them file claims. It increases the annual insurance rate cap in the statute. It's a graduated, going up 1% per year. There are very specific deadlines now to file claims, whether they're new claims or reopened claims, and defines the date that triggers those claims, such as hurricanes. It's when it makes landfall, or any other type of natural disaster, windstorm, flood, tornado. Basically, the date NOAA determines that the event took place. And there's now a pre-suit demand before filing suit that gives the insurance company a bunch of different options of, reevaluating the claim, requiring some form of mediation prior to it, or other type of stuff. So be familiar with it. The property insurance, it is a huge issue. There was at one point an effort in the legislation to add a requirement to the condo disclosure that required a disclosure for all prospective purchasers that associations had made claims with their property insurance exceeding a certain dollar amount. So it is a high priority issue of the insurance industry, and we will see it again.
All right. We have a couple minutes left now, and I'm answering a lot of the questions that have come through on the Q&A, and I'm kind of shocked there isn't as many questions as I suspected. If you have questions after we log off today at 12:15, feel free to email either of us. We can't answer very detailed questions regarding fact-specific situations at your association, but we can answer clarification questions, and we are happy to do so. And, the last couple slides here are about legislation that is not going forward that you will not have to worry about, but it was so, potentially terrible that we felt the need to discuss it anyway, and to highlight what could be coming in later years to get people to start thinking about it. One of those was?
So, legislative is always an adventure with everybody and their ideas. And, part of the reason we wanted to highlight what failed is because you see a lot of what passed was stuff that failed before. The HOA leasing one that we've all just discussed bounded around for several years, and you kept watching it get further and further along. And then finally this year it broke through. And as I was looking back at my notes from last year's legislative update for the bar, if you look at what came out of Senate Bill 630, most everything that failed last year came back. We had board term limits, condo transfer fees, official records concerns, conflict of interest provisions, natural gas installations, condo arbitration reform, HOA rental restrictions, HOA election disputes. Those were all in the last bill in 2020. They were there in 2019. So part of the reason we highlight what failed is so you have an idea of what's lurking on the horizon, and we may be coming back to you in 2022. We may be coming back to you in 2024, or we may never come back to you. But this is stuff. And so one of the ones that dropped that was kind of a bombshell, and it got fairly far in the Senate, and has some very, very well-connected people backing it in industry, was investments by condo associations. And so what did it do? Well, it was creative. The final version of this that got pretty much all the way through the Senate except final approval would have allowed a condo association to invest their reserve account funds in equities unless prohibited by the declaration. You still would have had to have approval by the majority of owners like you do to use reserve for other purposes. But then, as it was being used casually, the condo could have taken their $3 million of reserves and shorted GameStop stock. That was effectively what was there. It required a board to have a written investment policy that had to be approved annually. And the board was required to select an investment advisor. It was not related to a board member or unit owner. And the only restriction on what you can invest in are those equities that the state was prohibited invested in. So you'll hear on the news from time to time, the state can't invest in this particular company because they're doing this type of political statement, or they're in some other issue. And so that would have only been the restriction on what could have been invested. Principal, earnings, and interest would have to be available at no cost within 15 days of delivery. And then it amended 7/18/30/26 to get the contract with investment advisor out of the requirements of the statute. This one I've seen, I think 3 straight legislative sessions now in some format. It made it all the way through the Senate pretty well and died in the House because, fortunately, there were people in place to knock it out. But again, we highlight what failed because, as I always say, what fails is usually what comes back.
All right, the next one that failed is another great one. Let's see. The DBPR criminal pilot program. What is this all about? This looks scary.
Yeah, we've heard for years the criminal penalties in condominiums and the effort that it has to get addressed. And there are particular people within the legislature representing certain districts where they say the fraud and criminal activity still exists. And so we need legislation to do it. And so effectively, they decided that we're going to make a pilot program out of it and target South Florida. So it was going to be a fraud investigation program within the division that would only cover condo fraud and corruption in Broward, Miami-Dade, and Monroe counties. So Palm Beach County, you barely made the cutoff. If you get across the border in there, you were fine. It was a pilot program to review complaints for these counties and determine if further investigation was needed and criminal prosecution warranted. And the division was given a ton of power. Subpoena, audit, investigative. They effectively became a mini judicial type entity, sort of a state attorney almost, to go into the condos and would be able to go through, audit, investigate, and review alleged fraud. And then if they found that there was sufficient evidence for criminal prosecution, the division was going to be required to send the case to the state attorney. And so we talk about stuff that failed. This one didn't get as far as the reserve investment, but it pops up and it continues to be an issue, as there are many of the legislatures from down in these counties that say that this is still an issue, particularly within condominiums, that needs to be addressed. And this was an effort to try and limit it and say, okay, let's run a test in these 3 counties, see how it works. And then if it's successful, obviously, then they would expand it going state forward, because nothing in the legislature ever stays contained to a small group. If there's a sunset clause, it's going to get extended. If there's a jurisdictional limitation, it's going to get expanded. So be aware of those 2 lurking around there, because we expect to have them pop up again next session.
Let's hope not. This criminal fraud thing is concerning, but we will see. Hopefully everyone can behave and we don't have to have the criminal fraud program next year as well. That's the end of the program today. We hope that you have learned a lot. As I keep emphasizing, most of this stuff will likely be effective July 1. So we wanted to give you a heads up so you could start planning, incorporating into your processes and protocols. HOA Leasing, very big deal. If you want your amendment on that before July 1. We'll be back for more courses. We thank you. We hope you have a great day. Shawn, any final thoughts on legislation or otherwise?
We've had stuff, everything through. The key takeaways from here is obviously when it comes to the collection issue and the notice changing, the courtesy notice in the HOA leasing, you do have this narrow window, and that, as Allison knows, that's the reason we're here more than anything, give you the preview of what's coming to prepare, but also you have a limited chance to get ahead of these. And so if you want to do so, I know as several associations I've had at least address it with me of, okay, we need to look at leasing restrictions because we have this narrow window.
All right, everybody get ready, and thanks for attending. Please check out our website for our further courses. Please submit the course evaluation. We do look at those, and if you have topics for suggestion for further courses, we do look at those. I'm very interested to hear what you want to learn about next time. Please let us know. Thank you very much.